Good morning. All right, thank you so much. Good morning, everybody out there. We've got some more frequently asked questions that we wanted to talk about today. I was, a lot of times most of the time I'll appear here with Justin Crocker, and I like to do that because I kind of give my point of view as a prosecutor, even though I've done defense work for many years too. But I like to talk about the point of view as a prosecutor, and he'll talk about the point of view as a defense attorney. And he's unable to be here today because he's in court. And unfortunately, when you're a lawyer in a small town, you tend to be in court a lot. So it's been difficult to get our schedules, to where we could both appear on here at the same time. I did want to mention I like to give a shout out to anybody who wants to contact him and give the number. His number is 731-502. If you have any questions about anything talk about today and you need to talk to him about it privately, that'd be fine. Also, what we like to do is, I'm always thinking of things I've dealt with in the past, issues, and that's where we come up with the questions. And if you have something that a topic you want us to discuss, we're happy to do that. We can't really get into specifics of a particular case because we're both lawyers, but we're not representing anybody. This is just general information for purposes, for entertainment purposes and for purposes to give some general knowledge about certain topics. But we're happy to discuss a topic and talk about generally how things are on that particular topic. So my email address is CoreyMorganLaw, that's CoreyMorganLaw @iCloud.com. Once again, CoreyMorganLaw @iCloud.com. You're welcome to send me an email, and I'd be happy to talk about whatever topic. Maybe we try to cover as much as we can, but there are certain topics that we haven't probably even talked about. So anyway, and we're just talking too about things that deal with the criminal justice system. Okay, let's get started here. The first question is, I was shopping in a store and I was stopped because the employee said I was shoplifting. Can they do this? And generally speaking, the answer is yes. A person can be temporarily detained. There's a statute in Kentucky that we have, and I think every state in the union has. It's KRS 433.236. That's our version of it. It's called a shopkeeper's privilege. Now, the shopkeeper's privilege is where you can detain briefly a shoplifting suspect, and it gives in detail, the reasons, for doing that. You have to do it in a reasonable manner for a reasonable length of time, and the person has to have probable cause. The business employee has to have probable cause to believe that any goods that they're holding for sale have been unlawfully taken by the person. But they have to have probable cause, and if they do, they can hold that person for a reasonable manner, for a reasonable length of time. They can request identification. They can verify the identification that they've requested. They can make a reasonable inquiry about, whether the person has any unpurchased merchandise on his or her person, and a reasonable investigation into the ownership of that. Because sometimes we take things in a store, and I know females a lot of times will take things in a store in a purse. So the question is, well, that item in the purse, it may not be purchased, but that might have been something the person has brought in. They can do an investigation into that sort of thing. And then contact a law enforcement officer and all that. But once again, it's got the question is, it is a reasonable manner for a reasonable length of time, and there has to be a probable cause to do that. And if there's not, if there's a problem with that, then it could be for the business could be sued for unlawful imprisonment, and this keeps the business from being sued for unlawful imprisonment. It keeps the employee from being charged criminally for unlawfully detaining someone. So that's the whole purpose of that. And I'll read on Facebook sometimes people will say, I went through a self-checkout, and I got my receipt and I'm walking, and they say they want to look at my receipt, and I just keep walking. I see stuff like that, and number one, I think, well, man, I don't know if I would want to, risk them calling the police or saying I've stolen something, or, for doing that. But I guess technically, as a technical matter, legally, if they don't have probable cause to believe that you've stolen something, they can't stop you, So, I mean, I'm not advising anybody do that. My advice is always to anybody, if they ask, show them the receipt. If you don't like giving the receipt, don't go through the self-checkout. Just like, I shop at Sam's quite a bit, and we have to, when we leave, they have to check everything, and that's part of knowing that they do that. Do they have a right to detain me? Technically, no, but that's not you always got to pick your battles. That's not a battle I would want to choose to fight on that. But as far as the shopkeeper's privilege, there has to be, like I said, probable cause for that. Okay, that's first question. Second question: I'm a victim in a criminal case. I have property damage because of the crime in the amount of $2,178. Can I get reimbursed for what I had to pay to fix my property? And the short answer on that is yes, you can. Part of a resolution of a criminal case, and part of what we look to as a prosecutor is, we want you to be reimbursed for whatever it is that the crime cost you. It's certainly not a perfect system or anything like that, but for the most part, we can get as part of a resolution of a case, that defendant has to pay the restitution to the victim. Now, then the question becomes: does the victim want and I'm going to talk about this a little bit more in a little bit, but does the victim want the defendant to go to jail, or does the victim want the defendant to be probated so they can be out working and paying them back? That's one of the things we have to talk to the victim about, and we try to share the pros and cons with the victim of what it is. Some victims just want the person in jail. Some victims just want the money. And both of which are very legitimate, reasons for doing things a particular way. Now, there are a few things that are problematic with that. First of all, will be over time. Some judges will set a very low amount, for that, and we'd sometimes a lot of times get the judge would set an amount, and I'm not going to say which judge, but we'd set an amount, for that we disagree with, that we think is going to take too long to pay. And in doing so, we have to make sure that the victim knows it's going to take a while. So what we started doing a lot of times is as part of the resolution saying, hey, you've got to pay $200 a month, or you've got to pay $300 a month, depending upon what the amount is and the defendant's ability to pay. So it's important to get that to where they can pay that amount back. In that way that the judge a lot of times, and rightfully so, will look to more at the defendant's ability to pay, more at the defendant's, if they have maybe a drug addiction or something like that's going to make it difficult for them to pay any money, while they're in rehab or things like that. When we're, as a prosecutor, we're more concerned. We're concerned about, of course, the defendant getting rehab and getting help. We're really concerned about the victim. The victim is mainly our focus on a lot of these cases. So, but bottom line is, it may take some time, to get paid because of that. And ultimately, it's up to the court to set the payment amount for that. It doesn't include interest, unfortunately. So, if you get paid, if it takes 3 years or 5 years to get paid back, those amounts you're receiving in year 3 and year 4 and year 5, they don't take into account any time value of money. So, you're getting back the money, but $1 today is worth more than $1 next year, and certainly is worth more than $1 5 years from now. So that's not taken into account whenever that's set, unfortunately. But the Kentucky Supreme Court said, you cannot charge interest for that. It only includes what you're out of pocket. Sometimes people will have, pain and suffering. Sometimes they'll have to go to therapy because of particular issues that happen. Sometimes they'll lose work. They might have difficulty to go to work for whatever reason, and it doesn't include those type of things. It's only what's actually out of pocket, or what it costs to repair, something like this particular case, this scenario here. So, and what we try to do as a prosecutor is say, okay, if you don't pay, you go to jail. So we want to make sure there's enough time there to where that person knows if they don't pay, they could in fact go to prison. And if they don't pay for a long enough period of time, the court will revoke the probation, and they'll put them in prison for that. If somebody does go to prison and they get out on parole, that's part of the parole as well. The parole requires them to pay any restitution that they have. So, but anyway, that's what victims typically have in restitution. Now, just talking about victims in general, there is, and I know I've mentioned this a few shows ago, but we have something called Marcy's Law that was passed by a Kentucky constitutional amendment, and what it does is it gives victims certain rights. Now, victims under Kentucky law, they include a spouse, adult, child, parent, sibling, grandparent, a victim who's also legally incapacitated would also include somebody who's a parent or guardian or custodian, or if the court appointed a court-appointed special advocate, that would also be a victim under the law as well. One of the cool things I think about Marcy's Law is a victim now has the right to hire an attorney, which before Marcy's Law was passed, the victim did not have. You could hire an attorney, but that you couldn't bring the attorney to court and have the attorney speak for you and things like that, which now can be done. We have also something called a Crime Victims Bill of Rights. The Crime Victims Bill of Rights is KRS 421.500, and Marcy's Law constitutional amendment works in conjunction with the Crime Victims Bill of Rights. One of the things that's we also have as a crime victim, I should say, is in the same chapter as the Crime Victims Bill of Rights is KRS 421.520. 421.520 is where the victim can submit a victim impact statement to the court, and that's very important. We try to do that whenever we always send out as part of our procedure to send out a victim impact information for the victim to fill out, and that victim impact information actually will be seen by the judge, will potentially be seen by the parole board. It's part of the final sentencing. That's something the judge will look at. And anyway, the victim impact is something that the court is supposed to take into account. According to the statute, the court is supposed to take into account that victim impact statement before sentencing the defendant. So that can be pretty important. In addition, there are some other rights under Marcy's Law. You have to have timely notice of all proceedings, and that includes. Well, let me back up from there. We have a victims' rights advocate in our office, as I think every Commonwealth Attorney's office does. The victims' rights advocate will notify the victims of court hearings, and they'll try to give them notice and plenty of time to where they can make arrangements, to be there. And hopefully, if they're there, of course, if they're there in court, they'll know what the next date is, and that helps. There's also something called VINE, and VINE will is something that you can sign up for, and they will notify you about various things, such as court dates. I think if the person's released on bail, they'll notify you, things like that. So it's important as well. And whatever office that you're dealing with if you're a victim, and whatever the Commonwealth's office you're dealing with, you want to talk with the victim's advocate and sign up for everything that you can get signed up for, because that will help you in getting information that's needed for the case. You have the right to be heard in any proceeding involving release, plea, sentencing, or consideration of a pardon, commutation, granting of reprieve, or other matter involving the right of a victim. So bottom line is, if it's dealing with a proceeding that is dealing with your right as a victim, you have the right to be heard. You have the right to be present at all proceedings, excuse me, other than the grand jury. Now, the grand jury is a secretive proceeding that, we can't have anybody in there except who the witness is, and of course the grand jurors and myself, and that's about it. But somebody to run the recorder, excuse me. But typically anything that's not grand jury, the victim has a right to be there. Got the right to consult with the attorney for the Commonwealth or any designee. In the bigger and the more serious the case, the more communication there will be between a Commonwealth Attorney's office and the victim. Now, you have right to reasonable protection from the accused. That's where the court will have a bond. There'll be bond conditions typically to stay away from a victim, or something. A lot of it depends on criminal history. If there's a big criminal history, then certainly that person becomes more dangerous than and there needs to be a higher bond in that regard. The court also has to take into consideration the safety of the victim's family in setting the bail and the conditions of release, as I'm talking about. Full restitution has to be paid, which we talked about. There has to be fairness and consideration of the victim's safety, dignity, and privacy. So the court, has to be respectful. The judge has to be respectful. That's what the law is. And I haven't had any issues relating to that. The court has always been, respectful. Okay, great. Thank you.
Strive to be your total healthcare partner, providing a full-service pharmacy with immunizations and compounding. In addition to prescription service, we also carry a full line of home medical equipment, from hospital beds and lift chairs to CPAPs, BiPAPs, and home oxygen units. Our home medical equipment department provides free setup and delivery in Logan and surrounding counties, and our respiratory therapist, Angie, is on staff to assist you. Raleigh White is a local source for diabetic footwear and testing supplies, walkers, crutches, and canes, plus a variety of braces, wraps, and supports. We'll gladly handle the billing for Medicare and most other insurance companies, making sure the process is as easy as possible so you can focus on getting healthy. I'm Leslie. Come see me at Raleigh White on the Square, downtown Russellville, or call 270-726-7626.
I've often said air conditioning is my favorite modern invention, but to be perfectly honest, central heat doesn't fall far behind. It's amazing how much trouble it causes going to die in the middle of the coldest night or hottest day of the year. That's why Night Electric Heating and Cooling offers 24/7 emergency service too. Call 270-726-3818 and put the power of Night Electric to work for you. Their trained technicians will quickly return you to a comfortable condition. That's Night Electric Heating and Cooling, 270-726-3818, 270-726-3818. One call and they do it all. License number MO4318.
Tired of watching your TV bill go up month after month? Maybe you've recently lost your TV provider. Or have you found you're actually paying more for all those streaming services than you were with traditional TV service? It's time to talk TV with American Cable, your local Dish Premier retailer. They offer terrific dish programming starting at just $84.99 a month with free professional installation and a 2-year price lock guarantee. American Cable provides reliable satellite TV service with an easy-to-use guide and remote. No searching through dozens and dozens of apps trying to find what you want to watch. Just a simple display and the comfort of knowing which channels are your favorites. If you've received a special offer from Dish in the mail, bring it in because American Cable can honor those too. So don't call the 800 number and jump through those hoops. Talk TV today with American Cable, 270-847-4542, or visit them at 223 North Main Street in Russellville. Restrictions apply. Call for details.
All right, we are back here. As I was stating, I was talking about the Marsy's Law Rights, and the best thing to do if you want to look at the Crime Victims Bill of Rights that we have in Kentucky is go to a Google search or whatever your favorite search engine is, and type in KRS 421.500. That's KRS 421.500, and it'll bring up information relating to that. And once again, there is a victims' rights advocate in probably every Commonwealth's attorney's office in Kentucky, so you might want to contact them as well if you have any questions relating to this and you're involved as a victim in a case. Okay, next, the prosecutor has offered the person who assaulted me 5 years in prison. I think he should receive at least 10 years. Doesn't a prosecutor have to do what a victim wants? And the short answer to that is no. The prosecutor is not required to do what a victim wants, even, with all the rights, Marsy's Law, and the requirement to consult with the victim. Now, as a Commonwealth attorney, I represent the state of Kentucky, or the Commonwealth of Kentucky. That's who I represent. I don't represent victims. I don't represent any witnesses. So I have to do what I believe is in the best interests of the Commonwealth of Kentucky, which means the best interests of the citizens of my jurisdiction. That's what I have to do. Sometimes that is doing exactly what the victim wants. Sometimes it is not. And the more personal the crime, such as a child sex case, I'm going to do, if there's a child sex case or an adult sex case, something that's a very personal crime, I'm more likely to do what the victim wants than if it's something that can be replaced by money. So if there's a theft or something that can be replaced by money, now some thefts can't. Certain things are stolen. I've dealt cases where somebody steals an urn that has ashes from a spouse who's passed away. I've dealt with cases like that. Those can't be easily replaced at all. So I'm going to take that in more consideration because that's personal. That's very, very personal, and I'm more likely to do what the victim wants if it's personal. However, one of the things I've dealt with for years and years are victims who contact the police and they want to put the defendant under the jail, and then shortly after, 2 or 3 or 4 days later, they're like, "Oh, I want to dismiss the case. I want to get back with the person." And usually it's a woman who's the victim and a man who is the defendant. Not always, but about 90+% of the time, that's what it is. And she'll want to dismiss the case and get back with the boyfriend or the spouse, or and in those cases, I'm not really that much in a hurry to be dismissing cases, particularly if it's a domestic violence case like that and there is a history of domestic violence from the defendant. Sometimes I won't dismiss it at all. I'm going to move forward and prosecute it, regardless of what the victim wants. And those are the type of cases usually even if the victim wants something, you totally disregard what the victim says because of you want to make sure other people don't get hurt, and you want to make sure that victim doesn't get killed in the future, which sometimes happens because it gets worse and worse, and that's what it leads up to in these domestic violence cases. So in cases like that, we are going to prosecute no matter what the victim wants, and sometimes they get mad. Like about a month ago, there was one that kept calling our office, wanting to dismiss a case, saying she'd gotten a subpoena and she wasn't testifying. She'll show up in court, but she's not helping us in any way, and she was being real hateful to everybody in the office, and I talked to her in court, and she, in one of the back rooms, and she was just real hateful and all that, because I told her, I'm like, I'm going to prosecute because he has a history, like a long history of beating you up, and this is just the most recent thing, that included strangulation, and we have to move forward on things to try to protect the community. That's one of the things that is very important in my job and any prosecutor's job. So that's important. And keep in mind, defense attorneys will sometimes, their main goal is to dismiss a case. And if they can't dismiss a case, they want to get something that either doesn't have a guilty plea like a rule of diversion or deferred prosecution, or they want a felony pretrial diversion where the person pleads guilty and later on it may be dismissed if it gets, if they comply with all the conditions. Then if that can't be done, they want their client probated. And then if they can't do that, they want the client to go to jail as few number of years as possible. That's essentially what a good defense attorney is going to want to do, try to protect his or her client. So a lot of times this victim will be on the side of the defense. That's what happens. It's just a really strange situation, but I've had it happen numerous times in domestic violence cases. Okay, we'll move to the next one. My lawyer tells me that the prosecution is going to put my texts and emails into evidence. Can they do that? What about Facebook or Instagram posts? And the short answer, again, I always say short answer, or because it depends on what the circumstances are, but for the most part, yes, they can be put into evidence, whether it's text messages or Facebook or Instagram posts, emails. The question is, can they be authenticated? That's usually what we run into to make sure it's that person's email or that person's text. If it can be authenticated and the court considers it relevant, and it doesn't take a lot to authenticate something. It doesn't take a lot for the court to think something is relevant for a particular case. It can be made into evidence. I remember one time I put on my Facebook or I shared for that I saw somebody had put on, and it said, "Dance like no one is watching, but text and post and email like it will be read in court one day." And I agree with that, because it's very, very possible anything you send, whether it's a text message or an email, just think you might, that might be used against you at some point. So always be careful what you say. Even when, I talk with people, sometimes I'm thinking, well, gosh, I could be being recorded right now. You just don't know. Today with all the technology, you don't really know in this day and time whether you're being recorded or whether something will be used. So got to be careful on that. Okay, next one. The Drug Task Force set up a purchase from me with a confidential informant. Isn't this entrapment? Now, the confidential informant, what they call a CI, You'll hear that term a lot, if you're dealing with drug cases. CI is a confidential informant who goes and purchases drugs from somebody, and they'll be recorded. And I've had numerous cases where there's CI, controlled buys on that, and the question is, in this case, isn't it entrapment? Now, before I say yes or no, I want to tell you that generally speaking, in cases, criminal cases, you have 5 types of defenses. There's either one. The first one is it's an accident and not a crime. That's one of the defenses. The second one is can't prove beyond a reasonable doubt. It's like, well, prove it. Prove I did it. You can't prove it beyond a reasonable doubt. The third is identity. That's it wasn't me type defense. The fourth is I did it, but I was justified in doing it. And 5, the fifth type of defense is the devil made me do it. That's essentially insanity or some type of responsibility defense. Those are the 5 defenses you're going to see in criminal cases. Then in the entrapment defense is a justification defense, kind of like self-defense or some other type of defense where it's, yeah, I did it, but I had reason to do it, and that's what the entrapment is. It's a type of justification. You're justified in the actions that you have taken. So the generally speaking, the court is likely not going to consider that entrapment, except under extreme circumstances. Entrapment usually has to be pretty extreme in the circumstances on that. Here's an example. There's a case called Ferris versus Commonwealth. I was just looking at some case law on this, and in this case, this is the head note that I'll read to you. It says a defendant accused of trafficking in cocaine is entitled to a jury instruction on entrapment, since his testimony that he 1 never transferred drugs before, 2 only knew where to locate cocaine because of his prior usage, and 3 received no benefit from his participation in the transfer of cocaine other than satisfying an undercover police informant for whom he had feelings, supports his entrapment defense. So the court said, yes, you can give an entrapment instruction because of the unique circumstances here. He never never transferred drugs before, only knew where the cocaine was because he had used it personally, and the person who got him to sell was somebody he essentially had the hots for. He really liked this police informant, and the only reason he did it was because he was really close to her. So had the police not used that individual, probably he would never sold the drugs. It was trafficking cocaine is what the charge was. But you see, that is a kind of an extreme example where they said, yeah, you can use a entrapment instruction. Here's another case. This is kind of the general rule. It's a case called Commonwealth versus Day. It's a 1999 case. It says defense of entrapment is available when there is evidence that a defendant was induced by police authorities or someone acting in cooperation with them to commit a criminal act which he was not otherwise disposed to commit, even though defendant admittedly committed the offense if the criminal design was conceived in the mind of the government agent who then induced or lured defendant into his commission. Strong public policy stops government from convicting him for it. So what they're saying is you have to commit the criminal act because you're disposed to commit the criminal act, not because somebody else made you commit it and got you to where you conceived of this crime that you wouldn't otherwise conceive of. So if you can show that to the court and to the judge will allow an entrapment instruction for the jury. Keep in mind, the jury can only do what the instructions are, what the law is that's given to them. So, but that's what that is. Okay, go ahead. Thank you.
Commonwealth Attorney Corey Morgan Lewis, Commonwealth Attorney for Allen and Simpson counties, conducting and teaching. He's a professor for the Citizens Law School classes, and he'll be back to continue his criminal activity.
At Young Funeral Home, we realize there's no such thing as a one-size-fits-all funeral. That's why we offer a full range of services and monuments, because everyone deserves a personalized service that reflects their final wishes. This is Wayne Reeves. If you have questions about pre-planning a funeral service, I invite you to visit Young Funeral Home. We will help you create the service you want without leaving the task to your grieving family. Young Funeral Home with chapels in Russellville and Auburn.
Riley White Drugs provides the highest levels of customer service that may sometimes seem old-fashioned by modern terms. They offer free delivery in a local delivery area and emergency prescription services available after hours and on Sundays and holidays. But Riley White is certainly up to date when it comes to modern technology. Whether using RileyWhiteDrugs.com or RX Local, their easy-to-use mobile app, you can securely view your drug history, prescriber information, insurance, and allergies. Make it even easier for you to review medications with your doctor. You can set up Riley White prescription reminders, and customers and family members can be linked to a single account, which makes it easier to refill for one or all members of the family with one simple login. Riley White is your full-service pharmacy with medical equipment, prescriptions, immunizations, and more on the square in downtown Russellville.
All right, we are back here. We were talking about entrapment, and just so if you want to look up the statute, it's KRS 505.010. That's KRS 505.010. So yeah, but once again, you can just Google that and it'll pull it up. Now next, the judge put me in jail because he didn't like what I said in court. Can he do that? And the answer is maybe. Depends on what you said. That's the question. You know, if you say certain things to a judge, you can most assuredly that you will be put in jail for what you said. Those are things that are would be considered contempt. A good example, we had a recent case over in Simpson County, I should say a recent incident over in Simpson County on Wednesday when we had jury orientation, where I was actually back in the grand jury room, so I didn't see it, but a juror kind of acted a fool, I guess is the best way to put it, and was saying things to the bailiffs and wound up calling the judge a bully and things like that. Well, the judge wound up putting him in jail, which any judge in the United States would have put him in jail for the things he was saying and doing. But he put him in jail for contempt. And the question becomes, well, how long can you have somebody in jail for contempt? Well, what the U.S. Supreme Court has said is that you can put somebody in jail for contempt for a period of less than 6 months. If it's 6 months or more, then only a jury can put somebody in jail for 6 months or more for a contempt. So typically you see, that's why you see judges, will say 5 months, 29 days. That's what they, that's what they'll typically have is that as the sentence, and they may say, okay, 5 months, 29 days, but you're going to serve 30, and the rest of it will be probated on condition you don't, do anything like that again, or something like that is what typically will be done. But it's contempt. Now, contempt. When I say contempt, that refers to any time there's willful disobedience. I should say disobedience to or disregard of a court function or order. So if you're causing the court to not be able to function and you're being disobedient, then that's contempt. So generally any misconduct in the presence of the judicial system would be considered contempt. Anything that blatantly interferes with the court's ability to administer justice, that would be contempt. If you insult the dignity of the court, that is contempt. Also, anytime the court makes a court order, that court order, if you violate that court order, then that would be considered contempt. Now, there are different types of contempt. There's criminal contempt. This is when it results in punitive sanctions because somebody did something and you want to punish the offender for maybe disrupting the court's business or disrespecting the authority of the court. As we said, the court can do 5 months, 29 days, and a $500 fine or both without a jury trial. So, it could be just a fine only type of contempt. Now, like I said, if it's 6 months or more, a jury trial must be held. And that's a U.S. Supreme Court case. It's Munitz versus Hoffman, which is 1975 case. Now, there's also a type of contempt that's called civil contempt. Civil contempt is when somebody fails to comply with a court order, and this is more of a remedial type measure rather than a punitive. It's when the court will find that somebody has violated a court order, and it's many times it's said that the defendant has the keys to the jailhouse in his or her hands, because if you comply with the court order, then you get let out of jail. So that's a civil contempt. Criminal contempt to punish, civil contempt to require compliance. It's a remedial type action. Now, other ways to determine contempt and look at that is whether it's indirect contempt or direct contempt. Now, direct contempt happens in the presence of the court. Example of that would be if someone starts yelling at the judge, or you call the judge a bully and start being mean to the bailiffs. That would be considered direct contempt. And what that does, because what you're doing is you're impeding the court's ability to function, and you're bringing disrespect upon the court. We have to all, whether the judge does things you agree with or disagree with, we all have to have respect for the judge and show respect for the judge in the courthouse. That's required. Now, indirect contempt is when it occurs outside of the presence of the court. An example of that would be if you improperly communicate with jurors outside of court. If you don't, or you say there's certain evidence that's subpoenaed, you have to turn over, and they don't turn over the subpoenaed evidence. Another example would be refusing to pay court-ordered child support. These are all things that would be considered indirect contempt, because direct contempt, as we said, happens in the presence of the court. The indirect contempt, these things are orders that don't happen in the presence of the court. Whenever there's an indirect contempt, you have additional rights that you don't have direct contempt. Direct contempt, the judge can just go ahead and put somebody in jail. You don't have to have a hearing. You just say, I saw it. The judge will be like, I saw it with my own eyes, and you just put somebody in jail because of what happened. Now, indirect contempt proceedings, you have a right to due process of law. What due process of law means is you have the right to notice of when the hearing will be, which gives you time to prepare for the hearing. Okay, you have the right to the hearing in presenting evidence at the hearing. You have the right to testify, or conversely, you have the right not to testify. Sometimes people don't want to testify. You have the right to compel witnesses to testify on your behalf, and that's done through subpoena. You have the right to review by higher court, meaning you can appeal whatever the decision is there, and you have a right to an appointed attorney before the court can impose jail. So you've got the right to an attorney, and it's like anything else, you have the right to your own attorney, to pick your attorney, if you're willing to pay for that attorney. And if you're not willing to pay for that attorney, then you can ask for an attorney. The court will appoint an attorney, and there has to be an attorney appointed before the court can impose jail on an indirect contempt hearing. There's a case in Kentucky, which the name escapes me right now, but that says that you have to have the attorney before you can impose jail. So, but that's how the contempt is in Kentucky, and it's very similar throughout the states because the U.S. Supreme Court has things that deal with criminal procedure and deal with the U.S. Constitution, such as due process. It's similar throughout the United States because the U.S. Supreme Court, like they do in other cases, have said this is the lowest you can go, or this is the highest you can go. What it's doing is giving rights. In this case, it's saying the highest you can go is 5 months, 29 days. Then when it hits 6 months, the defendant's got a right to a jury trial. So, okay. Now, let's see the next question here. What is Melanie's Law? Melanie's Law is something actually I have not dealt with to this point. What that is it's when an impaired driver causes a wreck, and if that wreck causes someone to either be killed or permanently disabled. If that's the case, the court can order the driver, the impaired person, who caused the wreck, to pay financial support for the dependents of the victim. It's technically not child support, and if y'all want to look at the statute, it's KRS 532.036. It's technically not child support, but it is financial support. And the court has to look at everything on that and can order that just like a child support payment up until the child turns 18 years of age, or 19 if the child is still enrolled in high school. And there are several factors that are set out in the statute I'm looking at the statute right now, that for the court to look to. Examples of that: financial needs and resources of the child. Number 2, financial resources and needs of the surviving parent or guardian of the child or dependent. 3, standard of living to which the child or dependent is accustomed. And it goes on and talks about some other things, but generally speaking, it's not like a child support worksheet or chart that you have in cases like a divorce or child custody. It's different. It's something where the court has to make the decision on how much money is to be paid, which could be less money than would be set out in the worksheet. Could be more money than set out in the worksheet. That's up to the discretion, the sound discretion of the court. So, but that is Melanie's Law. It is a fairly new law. Let's see. I was looking here. Yeah, it was effective June 29th of 2023. June 29th of 2023. So it's not even a year old from the time it became effective. So, but I haven't had that issue come up yet. I'm sure at some point it will, because we do have cases that are accidents. I've got a case over in Allen County right now that's pending, that's set for trial, that's dealing with a murder case in a DUI. And I don't think Melanie's Law is going to come into play there, because it was an older gentleman who was killed. But I can very well see that in the future, that might be something we have to deal with. Okay, next. I have had final sentencing, and my lawyer says I can file for shock probation. What does that mean? Now, that means that even after the court sentences someone to prison, the court has jurisdiction to let that person back out and put them on probation. It can't be done in every case. For instance, if it's a violent offense under the statute, you can't shock probate a violent offense. You can't probate a violent offense, and you can't shock probate a violent offense. So the court, if it's nonviolent and it's eligible, you have to the defendant has to file that within 30 days and 180 days. That has to be the period of time that it's filed, because after 180 days, the court, the circuit court, loses jurisdiction. The court can no longer do shock probation. And the purpose of the shock probation statute is to shock those who are incarcerated, and usually for people who are not familiar with the jail, and it's supposed to scare them into being law-abiding citizens, essentially. But I see it where it's not used like that anymore. They really need to amend, in my opinion, they need to amend the statute to where it's clear that, if you have a criminal history that's, longer than my arm, you don't need to be doing shock probation. That does not need to be something that the court grants. But as of right now, there's no restriction on the history, even though that was the main purpose of that. On that. Now the statute is KRS 439.265. If you want to take a look at that. Okay. Well, thank you. I appreciate it. Thank you to everybody. I appreciate that. Thank you.